Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. All right, friends, we are back in Calloway County with workers' compensation attorney Jeff Roberts. And Jeff, today we're going to go down a rabbit hole a little bit here. We're going to talk about if you suffer a workplace injury, is it possible to sue your employer beyond just workers' compensation?
Good morning, Jim. It's good to see you again. And I get that question asked a lot, to be honest. In workers' comp, as I've mentioned before, workers' comp is essentially a no-fault type of claim. In other words, if the employer does not have to be negligent for you to have a workers' compensation claim. If you lift a heavy box and rupture a disc in your back, well, the employer wasn't negligent in that situation, but you still have the workers' compensation claim. But the flip side of that is that the only claim you normally have against your employer is going to be a workers' compensation claim, even if they are negligent or even grossly negligent. It all goes back to, as I understand it from research, back to the turn of or early 1900s when manufacturing was starting to increase in the U.S., and there was kind of a quote-unquote grand bargain that was made back then because you had people that were getting hurt on the job. It wasn't from negligence, and so they weren't getting anything, and they were having to pay their own medical bills. They were being off work and not getting paid, and several workers who got injured were going bankrupt and losing homes, etc., because of that. And then you had the reverse situation where it was because of negligence or gross negligence on behalf of the employer, and then the lawsuit that developed as a result of that caused some businesses to shut down, and then employment, lots of jobs would be lost from that situation. So it was labor interests and business interests got together and developed the workers' compensation system. Part of that was that we're going to cover a lot larger group of people by saying that you don't have to have negligence, you don't have to have fault on the employer to be eligible to receive workers' comp. You just have to have been injured on the job. But the drawback or the what was given in exchange for that is that you don't get pain and suffering. You don't get all these other damages that cause a normal, like a car wreck case or a personal injury case, to be a higher damage case. So you don't get to recover that. What you can recover is going to be significantly limited, and past medical bill or your medical, lost wages, permanent impairment, or permanent disability benefits, vocational rehabilitation. That's about the types of benefits that you can recover under workers' comp.
Well, there's also the factors that the comp benefits kick in relatively quickly after the injury once it's been reported versus like a car wreck where you pretty much have to go through the entire claim and finally there's a settlement or a verdict at the end of that.
Exactly, and that's part of it is the medical and the lost wages are being paid to you while they're being incurred instead of you go through all of it and then get reimbursed a year and a half down the road.
Again, because negligence here is not really a factor.
Negligence is not a factor. And so, that was the quote-unquote grand bargain that was made from a workers' comp perspective. Part of that grand bargain was what is referred to frequently as the exclusive remedy. And I know Kentucky has this, and every state I've looked at has an exclusive remedy provision that says if you are injured on the job and it is covered by workers' comp, then your exclusive remedy is the workers' compensation. Exclusive remedy against your employer is your workers' compensation claim. So if your employer is negligent or gross negligent, that doesn't allow you to sue the employer outside of workers' comp. The only claim you have is the workers' compensation claim, and part of that also extends to your coworkers, because employers act through their employees. So, I mean, if you're driving in a vehicle, you're the passenger, your coworker's driving, and they run a red light and T-bone another car, and you get seriously injured, you cannot sue your coworker for that accident. They are the beneficiary of the exclusive remedy as well. You're still limited in your claim against would be still the workers' comp claim against the employer. Now, if the other driver that's not connected with your employment was somehow at fault, then you can pursue that claim. We've talked about those type of third-party claims before, but your claim against the employer is going to be the exclusive remedy of workers' comp. There are a few exceptions to the exclusive remedy in Kentucky's Workers' Compensation Act. The first one, and one I see more frequently than any other, is if the employer fails to secure workers' compensation coverage. As you mentioned, when you have a work injury, the medical is paid as it's being incurred. The lost wages are being paid as they're being incurred, called temporary total disability benefits. Well, if the employer doesn't secure workers' compensation coverage, that doesn't occur. And so the employer, by not securing workers' compensation coverage, waives the exclusive remedy provisions of the Workers' Compensation Act.
Related to that topic, if we go all the way back to episode 33, we specifically answer the question, what happens if my employer doesn't have workers' comp? Good news is there is a safety net in Kentucky that'll get you taken care of. The state kind of steps in, and there are ways to handle that. But we're now talking about other actions where they negligently decided, I just don't want to pay for workers' comp.
Correct. If they choose not to have workers' compensation, and it can be a variety of situations. Some is they may not realize that they are required to have workers' compensation. That doesn't occur very often.
I think you've said in the past, and I mean, we've done a lot of workers' comp episodes, and you've said if you have one employee, you are then required to have workers' comp. Is that generally true?
Generally true. If you have an employee that is not hired for domestic type work, so if you hire one person to come in to clean your home, for instance, that you don't have to provide comp coverage for that one person. But if you have one employee, like here in my law office, I have more than just one staff member. But if all I had was one receptionist, I still have to have workers' compensation coverage for that one receptionist. And so, so workers' comp is mandatory, as essentially. There are certain occupations where a workers' comp is not required, agriculture being the primary one. But where I see people or employers not insured are a couple of different situations. One is where the person is basically intentionally trying to circumvent having to have workers' comp coverage and take out taxes and pay the employer share of payroll taxes by classifying someone who is an employee as an independent contractor.
Yep. Misclassifications.
Yes, misclassification of the employee. And in Kentucky, just because you say the person's an independent contractor, that does not make the person an independent contractor. And in that situation, then we can pursue a claim against if the employer was negligent or a coworker was negligent, then you can pursue your personal injury claim against the employer and pursue a workers' compensation claim both. There is the uninsured employers fund set up to cover employees whose employers don't have workers' compensation, and will take care of that. Like a workers' comp insurance carrier in any other third-party case, they would have the right to be reimbursed if you recover money against the employer. In the civil case, the personal injury case from that situation, but the employer has waived workers' comp. And there can be a situation where in that field or in another where if they are like a subcontractor, then the general contractor's workers' comp insurance could kick in and could have to maybe kick in and pay for the workers' comp benefits for you, even if your direct employer did not have insurance, but the contractor above them, the general contractor, did. Then you can go after that general contractor's workers' comp insurance to cover and still have your potential personal injury claim against the employer because they've waived the workers' comp exclusive remedy by not securing workers' comp coverage. Another situation where I see a lack of coverage is when the employer is not based in Kentucky but accepts employment in Kentucky.
Interesting.
Yeah,
Okay.
because some companies, when you purchase insurance, you can purchase insurance coverage that's all states or multiple states, so it will cover you if you got, if I had an office in Tennessee, for instance, I could purchase coverage that would cover me and my employees in Kentucky and in Tennessee, either one, and cover in both states, or purchase two different plans depending on which way I wanted to do that. And like with trucking companies where the drivers are traveling through multiple states all the time, a lot of those, they get all state coverage, which means regardless of what state you're in, it's going to provide comp coverage for that state there. But some employers, and I see this more in the construction field than I do the trucking industry, but I do see this occur where you have a construction company out of Tennessee or Missouri or Indiana accept a job in Kentucky. They're in a border county or whatever, and they accept a job in Kentucky, and then the person gets injured in Kentucky. Well, if they get injured in Kentucky, it's a Kentucky workers' compensation claim, and the employer may only have coverage for Tennessee or Indiana or whatever state that they're based in, and not have the coverage that crosses state lines. And so I see failure to have coverage in those situations as well. And again, if that's the case, then you can look at the uninsured employers fund, or if there's a general contractor, you can go what's called up the ladder to the general contractor to get access to their workers' comp coverage. Part of the exclusive remedy, and I know I'm getting into the inside baseball type stuff here, but part of the exclusive remedy is it extends also, I said it extends to co-workers, but it extends to anyone that could be liable for your workers' comp benefit. So if you're if you work for a subcontractor and you're injured on the job and could potentially go against the general contractor, that general contractor has the benefit of the exclusive remedy provision as well. So you can't sue that general contractor, even if the general contractor was negligent.
You could still file for comp benefits, but you can't sue them
Correct.
For a third party action or something.
Correct. You can't sue them for negligence.
Okay, for negligence.
Yeah.
And I guess that kind of brings us to third party actions, third party claims. That's another issue here.
Correct. And that
You want to define what that is, I guess.
third party is essentially what referred to if you have a workers' comp injury. You've got the workers' comp claim, but if a third party caused your injury, first and second parties, you and the employer. So if a third party caused the injury, then you have a potential civil suit, personal injury claim against the one who caused the injury. If you travel for work and you're injured in a car wreck and the other driver's at fault and they're not a coworker in any way or anything of that nature, then you've got the car wreck case against that driver. If you're on a construction job site, building a office building, and there are multiple subcontractors on the site, the general contractor would have the exclusive remedy provision, but you're working as a plumber doing plumbing, and then they've got somebody that's doing iron work that's a subcontractor as well, and they don't bolt something in or drop something that hits you and causes injury. You can sue that that other subcontractor for personal injuries, as well as have your workers' compensation claim. So that's where the third party claims come in, is someone not involved in the employment relationship that causes the injury through negligence, and then you can pursue that claim. You have to establish negligence in those cases.
So if I'm on a job site, I'm working in the yard somewhere, FedEx driver comes up to deliver something and hits me. That's a third-party action.
That's a third-party action against
Okay.
FedEx and that driver.
And it doesn't have to be just FedEx, but I'm just
Correct.
using it as an example.
Correct.
But okay, so that's a third party. So there are situations when again you can go beyond just workers' compensation in terms of benefits or some type of legal case, I guess.
Yeah, third-party actions, you can go against that third party and have the workers' compensation
Right.
claim as well.
And that
Because
third party would also include the pain and suffering claim, right?
Yes.
Which is again that's something that you don't get under workers' comp.
correct.
So
Yes,
yeah,
you would have the pain and suffering aspect of that. The damages in those cases are generally going to be greater than what you're going to recover in workers' comp. So most people, it's beneficial to pursue the workers' compensation claim because those benefits are paid as the treatment's going on. The lost wages are being incurred. You're getting paid the temporary total disability benefits for those lost wages, and then pursue the third-party claim because that's where you get pain and suffering and you've lost whenever you're off work for an injury. Even if you're getting 2/3, you've lost 1/3 of your benefits from that standpoint. And most people that I represent end up having to use savings and things of that nature to help pay their bills. And so that third party action, the negligence action, can help to, the workers' comp claim can as well, but the negligence action can help to replenish whatever you've had to spend and hopefully add more to that as well.
Well, a couple of weeks ago, we were recording a different episode, and we talked about the fact that you handle personal injury claims, you handle workers' compensation claims, and also Social Security disability claims. And I don't know, and I've worked with attorneys for about 20 years now, I don't know of many that actually handle all three different types of injury-related claims, but actually you do. And how can that somehow be an advantage for a client?
Well, the advantage, I do handle all three of those type of claims. The advantage to the client can be, there's several advantages to the client to have one attorney handling all of those cases if you have all of those cases. One is in regard to having a workers' compensation and a third-party claim is the workers' compensation carrier is going to be entitled to a portion of the recovery in the third-party action. If you have one attorney handling both of those claims, then the attorney is very familiar with what workers' comp is paid out and can negotiate with the comp carrier or resolve the comp claim in a way that limits or eliminates them getting any portion of the personal injury settlement. There are times when you have two attorneys handling those cases where the attorneys aren't coordinating with each other like they ought to. In fact, not too long ago, I had an attorney call me up to ask questions about that because they had the personal injury side. Unbeknownst to them, the attorney handling the comp claim had settled it without taking into account or letting him know anything about the settlement, and settled it in a way that it was going to have a effect on his personal injury. And he's talking to me about if there's ways he could limit that at that point in time. So if there's not that coordination, it can end up having an adverse impact on the client or the injured party.
Also, issues related to medical records and things like that. You've got all of those right there, so you don't have to order multiple sets and things like that. Which ultimately, in a contingency fee case, the client typically has to, at the end of the case, pay for those related case expenses because you front those as part of your representation.
Yes, I advance litigation expenses. Those are contingent upon recovery, just like the attorney fee. I only get paid at the end of the case when I am successful in the case. So when I put money in my client's pockets, when I get paid my attorney fee, and that's when I get reimbursed my expenses. If we're not successful, they don't owe me anything. But yes, that's another benefit of having one attorney. If I ordered the medical records from the neurosurgeon in the case for the workers' compensation claim, I still have those records I can use in the personal injury. I don't have to order them a second time. So I paid for them one time, and I get to use them in both cases, or for a Social Security case in 3 cases.
Or if there's a deposition and you've got to travel, you're the one person. You're not having multiple attorneys.
Exactly, and exactly. That's part of it, and I can ask the questions in the deposition that I need for both cases to some extent. It can be difficult to get the deposition used in both cases, but I can get the information I need and then get it by a medical report or something to use in the workers' compensation claim from there. So, if you can have one attorney handling both, it's probably to your benefit. It's definitely to your benefit to make sure that whoever's handling one case is coordinating with whoever's handling the comp claim is coordinating with who's handling the personal injury claim if it's not the same person.
That makes sense. And friends, I know we kind of glossed over this contingency fee topic as part of those answers, but if you want to go back to episode 56, and I'll put a link to that in the other episodes in the show notes, you'll be able to listen to really what is a contingency fee, how does that work, how does it work specifically with Jeff, because he handles his cases, I think, a little bit differently than other attorneys, so to your benefit, actually. So that's something to pay attention to. So episode 56, and once again in the show notes, there'll be a link to that. Jeff, we were talking about the exclusive remedy and the fact that, in a lot of cases, the only claim you can file is the workers' comp claim when you're injured on the job. But there are some exceptions, and we've talked about two of those. There's also the third exception, which is the intent to injure. And do you want to talk about that a little bit? Because I wasn't even thinking about that when we were prepping for this, but it makes a lot of sense. There may be a reason that claim needs to be pursued.
Yeah, exactly. The intent to injure is the other way. You've got if the employer fails to purchase, then you can sue the employer. You've got the potential third party against another person. The only other way, though, besides failure to purchase comp coverage, the only other way to sue your employer outside the exclusive remedy, if it's a claim covered by workers' comp, is through the intent to injure exception to the Workers' Compensation Act. And that is a very, very limited exception. And the courts, the way they have interpreted that exception is, to me, extremely narrow compared to what the statute says, because an intent to violate an OSHA regulation does not fall into that. There was a case several years ago, a couple of decades ago now, actually, I think, 2003, 2004 timeframe, where it was not my case, but it was an attorney I know, an attorney I respected, who handled the case, and I know the case was handled very well. And he was trying to fit the personal injury case in the intent to injure. And the injured party was working for a company that part of the job was to dig ditches and lay stuff in the ditches, pipes or whatever. I can't remember exactly what they were laying on, if it's cables, pipes. But the employee was in the ditch. They had dug the ditch 6-8 feet. I think it's 8 feet is over his head. And OSHA regulations provided that you either had to have a trench box to keep it from caving in, or slant the sides to keep it from caving in. The employer acknowledged in depositions that they knew that was the OSHA regulation, and they chose not to follow that OSHA regulation in this. Unfortunately, it caved in while the person was in the ditch working, and the person died as a result of the cave-in and not being gotten out quick enough, or they couldn't get him out quick enough in that situation. And that went all the way to there was a jury verdict in that case, and went up to the Kentucky Supreme Court, and the Kentucky Supreme Court said intentionally violating an OSHA regulation that results in a tragic fatality does not get around the exclusive remedy provision. It has to have, you have to have a specific intent to cause the injury to the injured worker. And while they intended to violate OSHA, they did not intend for this employee to be injured. So to really fit within that statute, the way it's interpreted, is you have to have a situation where the employer says, I don't like the way you interacted with that customer, pulls a gun out, shoots you, that that would fall within the intent to injure situation, but you have to have the employer have a specific intent to cause the injury to the worker before it would fall outside that exclusive remedy.
Wow, it's that narrow.
It's that
That's
narrow.
amazing.
Yeah, it's that opinion. I was shocked when I read that opinion when it first come out. I've revisited it again recently, actually, because I was asked about that in regard to the context of a gross negligence in regard to violating OSHA. And I wanted to go back and double check my memory and see if that was still good law. I thought it was because I knew I would have or expected I would remember a case that changed that, and it is unfortunately still law. I did notice, though, it was a 4-3 decision in the Supreme Court, so there may be the chance to get that changed because you had 3 justices that dissented and said this should not be covered by the exclusive remedy provision there. So it may be now because I don't know that any of the justices that made that decision are still on the court at this point. So you might could get a different result if you had a very egregious case like that one was. But it's and like I said, a lot of the legal community was very surprised when that decision come down the way it did. So
Wow, interesting. And, friends, we've done episodes on workplace fatalities. I'll put a link to that in there. I know that's not the direct purpose of that answer, but
right.
Obviously these are topics that do come up. And wow, I'm amazed that it's that narrow. But again, that's why this area of law is so complicated. And that's why you can't just make assumptions. Well, my buddy said, this is what. No, you need to seek out a qualified attorney who actually does this type of work. And Jeff, you've got offices both right here in Murray, where we are today, but you've also got one up in Hopkinsville, up in Christian County. You want to talk about the best way for somebody to contact you if they need to talk to you about a workers' compensation situation?
Yes, best way to contact me is to call. Phone number is 270-753-0053. And you can call that number. You're going to reach me whether I'm at the Murray office or the Hopkinsville office. That's still the number to call. And I also have an 800 number, 1-800-844-5108, rings to the exact same phone. So whichever one of those you call, it's going to come. If you call my office, you're going to get a live person. 95+% of the time, you're going to get a live person. If it's during office hours, if you call 2 o'clock in the morning, you're not getting a live person. But we do have, I prefer to have staff members answer the phone. I don't have third-party companies answering the phone that don't, the people that answer the phone work for me. And they know if I'm in the office or not in the office at the time when you call in. And if I can talk to you, I'll talk to you. If I can't, they'll get information and then we'll get back in touch with you. But if you've been injured on the job and you want to talk about what your rights are and what you may be entitled to, give me a call. If you've been injured in car wreck, same way. If you want to know about your rights are and what you may be entitled to, give me a call and I'll be happy to talk with you.
Well, and again, I want to come back and press this. What I think is, I can't say it's unique, but I can say it's uncommon for one attorney to handle all those various types of injuries that could be related to the same type of injury, where you have a workers' compensation claim, you have a third-party claim that deals with personal injury claims, where you also could eventually, unfortunately, have a Social Security disability claim. So all of that can come into play in one specific situation. And Jeff Roberts is able to handle all 3 of those, which a lot of times, a lot of other firms may have to farm that out, which is one of the reasons you get a lot of calls from your colleagues across the state of Kentucky, both Northern Kentucky, Eastern Kentucky, you're here in Western, obviously, Bowling Green, all these other areas, where they call you because they only handle one area, but hey, there's multiple claims here, so they're going to try to pull you in and get your work on the case as well.
Yes, that's true. And yeah, there are some attorneys that reach out anytime they have a workers' comp component to the case. They will reach out to me to see if I can get involved to handle the workers' comp component. And we've worked on cases in the past. They know my work, and so they reach out to me on those, and not just attorneys in Western Kentucky. As you say, I've got attorneys all over the state that do that from that perspective. But I do handle all types of cases injury type cases, the car wrecks, the workers' comp, Social Security, disability. All three of those are what I do day in, day out.
Outstanding. You've done it for 32 years, so I think you might know a little bit about this kind of stuff.
Yes, I've done it for quite a while now.
Yep. Friends, I would also encourage you, if you're thinking about, well, I just need some other proof or some other justification to pick up the phone and call Jeff, go out to Google and type in Roberts Law Office Murray. And what you're going to see is a whole bunch of Google reviews out there that you can read. And those are voluntary reviews, as you probably already realize, from other clients who have hired Jeff in the past, who have relied on Jeff to represent them, and obviously that impacts their families as well. And I think you're going to be very, very surprised at what you read. Jeff, you've done just fantastic work down here. You've developed a heck of a reputation, which again is why I think a lot of your colleagues from across the state are calling you on a regular basis to say, hey, can you get involved with my case?
Well, I appreciate you saying that. As you know, and it's on my website, and if you go to the reviews, you'll see it to some extent. But I kind of have an office motto or an office theme that we go by, which is to provide small town service and deliver big city results. And if you go to the reviews, I think you will see the clients are very happy with the results that we achieved for them, but also very happy with the way we handled in the service and the information we provided and how we kept them informed of what was going on in the case. So we tried to live up to providing small town service and delivering big city results, and I think we're doing a pretty good job of that.
Outstanding. Jeff, I'll see you in a couple of weeks.
Thank you.
Take care. Bye-bye.
Bye.
Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.